Hello everyone, and welcome to the Legal Eye on AI podcast with Anna and Oliver, where we discuss the EU AI Act and other European AI developments. I am Oliver Yaros, and I'm a partner in the London office of Mayer Brown, and I'm delighted to be co-hosting this series of podcasts with my partner and good friend, Anna Bruder.
Thanks, Oliver. Hi, everybody. I am a partner in the Frankfurt office of Mayer Brown. I have been working with Oliver, whom I also appreciate as a good friend, for 11 years, and we advise together clients in AI matters, as well as cybersecurity and privacy matters. I'm also delighted to be co-hosting this podcast with you, Oliver.
Thanks, Anna. So, in today's episode, we'll be providing an introduction to the EU AI Act and the UK approach. In this episode, we'll be covering the current status and the next steps towards the adoption of the EU AI Act, talking about the timeline for its provisions to start applying, and the steps that companies should be taking now in light of the EU AI Act requirements, as well as the UK approach to regulating AI. So, Anna, let's start with where we are and where we're headed. Can you tell us roughly what the EU AI Act is all about, what the current status is, and the next steps in its adoption?
Yes, absolutely, Oliver. What is the EU AI Act all about? Well, it's the world's first comprehensive regulation of artificial intelligence, really. It takes a risk-based approach, so depending on the level of risk that an AI system poses to the health and safety and fundamental rights of individuals, there are different sets of obligations that apply. Like the GDPR, it has extraterritorial effects, so it may apply to companies that are not established in the EU. And also, like the GDPR, it foresees even higher fines for non-compliance. We will talk a lot more about each of these aspects in the coming episodes of this series. And as to the status and next steps of adoption, well, actually, that's it. We now have all of the required adoptions by European institutions, and the legislative process is actually concluded. First, the European Parliament approved the text on the 13th of March 2024. Then on the 15th of May 2024, the Permanent Representatives Committee of the European Council approved it. And now, on the 21st of May, another specialized committee called TTE within the European Council has approved it as well, meaning that the text is now final and it will be published in the official journal of the EU in the coming weeks. After that, it will formally enter into force 20 days thereafter.
Great. Thanks very much, Anna. And what will happen after that, and how long will companies have to become compliant with the EU AI Act?
The Act is going to enter into effect 20 days after adoption, but the provisions will only start really applying after that. And there will be a staggered implementation. So 6 months after adoption of the text, some of the provisions will start applying. And then 9 months after, 12 months after, 24 months, and 36 months after that. So the really most important deadlines for the purposes of companies that are wondering if they have to do anything about it, I would say the 1 year deadline that will apply for generative purpose AI models. So what I mean is all provisions relating to general purpose AI will start applying 1 year after adoption. And then 2 years after adoption, the bulk of the obligations, including those that apply to high-risk AI systems, those provisions that are the most burdensome, as we will see, they will start applying 2 years later. And then 36 months, so 3 years for the rest of those provisions on high-risk AI systems. So the high-risk category is actually subdivided. One subcategory is areas like employment, education, etc., that will start applying 2 years after adoption. And the second subcategory are, so it's the use of AI in products that are subject to EU safety product legislation, like medical devices or civil aviation. And those are actually intended to start applying 3 years later because they are intertwined with already existing legislation on product safety.
How interesting, Anna. And of course, it won't be of surprise to anyone to know that AI, and in particular Gen AI, is something that a lot of organizations are thinking about adopting and using right now. So what about systems that were developed and placed on the market before the EU AI Act comes into force? What happens about that?
That's a great question, and Oliver, and one that many of our clients are asking us, right? So it really depends on the type of model. If it's a general purpose AI model, for example, LLM models, so the definition is really models that can generate a generality of output. Those there will be some provisions for the transition period. So a general purpose AI model that was put on the EU market in the 12 months before the Act enters into force, they will have 3 years to get compliant with the EU AI Act. So some clients ask me, what about AI models, general purpose AI models that were put on the market even before that, right? There are already, of course, many, like ChatGPT is a good example, right? Well, for those, actually, there are no provisions currently in the text. So they will likely not even be captured by the Act's obligations unless the model is modified later, right, or fine-tuned into a new model, which we can expect to happen, right, because the technological development is so rush right now.
Oh, I thought you were going to tell me there was nothing that needs to be done there, Anna. So I'm pleased that you've cleared that point up straight off. So thanks for that.
Before
So
people start, opening the champagne bottles, right?
I heard them. I heard them. So given that there are likely to be changes, even with systems that were developed and placed on the market before the EU AI Act comes into force, what should companies be doing now in order to comply with the EU AI Act?
Yeah, that's also a brilliant question. The first thing companies need to have is governance. That means they need to have a body within their organizations that is thinking about AI and thinking about these regulations, what they will mean for the company. So it can be a task force, a committee. It should involve all stakeholders that are relevant. So legal, compliance, IT, the product development teams. Um, it really depends on the organization, what they are doing, right, and what the structure is. But those key stakeholders, they need to be involved because AI is a multidisciplinary thing. It should try to make this governance body also as diverse as possible because diversity will help you look at things from this different perspectives and avoid bias actually as well. Once you have that body, they should actually assess each AI model or use case. And here are the key questions they should be asking. First question, what is the role of our organization on this AI model? Are we a provider? Are we a deployer? Are we an importer or a distributor? Or other? It's very important to know your role in the ecosystem because your obligations will depend on that assessment. The second big question is this general purpose AI or not? Also, because the obligations are different depending on that. If it is general purpose AI, is it likely to carry systemic risk? But that is something you will need lawyers to help you assess. But this is just a question you will need to ask yourself eventually. And if it's not a general purpose AI, what is the level of risk between unacceptable risk, high risk, limited risk, or low risk, or no risk at all? Because yeah, there are provisions and chapters of the UAI Act, regulating each of these. So based on this assessment, companies will be in a position to know which obligations, if any, apply to them.
Wonderful. So there is quite a bit of work to be done even before the EU AI Act comes into force. And apart from that, Are there any other provisions that already apply to AI systems that our clients need to be aware of?
Yes, there are. So the first one, obviously, GDPR, right? If you have a chatbot, for example, that is processing personal data when interacting with your customers, then you already need to have a legal basis for that. That should be doable with legitimate interest if it's not special category data. But if you have a chatbot asking people about their allergies, that could be considered health data. So you would need a legal basis under Article 9 GDPR. So there is a little bit of work you need to do there. On the transparency side as well, right? Your privacy notice should reflect that, among other aspects like data minimization, etc. The second thing I would like to highlight is digital regulation, like the DSA, the Digital Services Act. So under the DSA, very large online platforms, flops, for example, they are under the obligation to assess systemic risk in their provision of services and to take measures to mitigate those risks. And of course, if you're using Gen AI, that generates very specific risks, right? So interestingly, the European Commission has sent a formal request for information to several VLOPs a few weeks ago, asking about their use of Gen AI and how they have considered those risks when doing their systemic risk assessment and mitigation assessment. And this is particularly in light of the elections that are coming up in many different places in the world. They need these VLOPs, also the VLOSs, they need to be in a position to react quickly to in the event of a crisis. And third, but not least, cyber rules have an intersection with AI. So if you're a bank and you will be subject to DORA, the Digital Operational Resilience Act, starting January next year, and you are purchasing an AI model, that might very well constitute an ICT service. Maybe also not. It really depends, right? But you need to check that, because if it is, then all the DORA requirements will apply to that system as well.
Great. Well, that's brilliant, Anna. Thanks very much.
Of course, and maybe I can add that we are really privileged to be helping some clients think about these questions early on. We have developed, well, together really, Oliver, those toolkits for our client with modules to help them ask these questions and document their assessments. But I think I've done enough talking, Oliver. I think I'll let you do a bit of talking now. Can you tell us a bit about the UK approach? The approach that the UK has been taking in connection with regulating AI.
Sure, happy to answer your questions, Anna. So I think the UK has decided to take quite a different approach for the moment to the EU. It has decided to take what it has called a pro-innovation, less burdensome approach to AI regulation. It has decided at the moment not to issue any specific regulation on AI, but what it has done is it has proposed to orchestrate a series of guidance issued by different regulators in different sectors to ensure that companies are implementing AI in the right way. And this was set out in the UK government's view on AI regulation in a white paper of March 2023, and in response to a consultation on that white paper published in February 2024, the UK government confirmed that it would be moving forward with this approach. So the idea is that there are going to be 5 principles that the UK government is going to be asking regulators in the UK to bear in mind when setting out their guidance about how AI should be addressed in the UK. And those principles are pretty aligned with principles you see in other places in the world, like the OECD principles. So one principle is focusing on safety, security, and robustness of AI systems. Another principle is focused on ensuring appropriate transparency and explainability when using AI systems. Fairness, accountability, and governance when using AI systems is another two principles. And the final principle is ensuring that there is the ability to contest and seek redress for the use of AI systems where individuals are affected. So the way in which this works is that there are a number of regulators that may have oversight over how AI is used in different sectors. So, for example, the ICO, the Information Commissioner's Office, is responsible for overseeing the personal data and the regulation of personal data. So when AI intersects with the processing of personal data, they have a remit to publish guidance in that situation. The FCA is in charge of regulating the financial services sector, so they have a remit in this world, as do a number of other agencies like the Ofcom and the MHRA, for example, among others. So there's already been a few pieces of guidance published so far, which companies need to take into account when thinking about how to use AI in the UK. So, for example, the ICO has published guidance on how to ensure that personal data is processed lawfully by AI systems and how to assess risk when conducting things like data protection impact assessments. The ICO has also produced further guidance on things like how you explain decisions made using AI and how you use AI in combination with biometric technologies. So I think in terms of what the landscape in the UK is right now, it isn't hard specific regulation focused on AI, but it is guidance issued by different regulators that organizations need to bear in mind, that is being coordinated by the regulators and by the UK government. And we'll continue to see that picture evolve over time.
Very interesting. So I know we'll talk more about the global compliance aspects, but maybe focusing between the UK and the EU, what is your take that UK companies or really European companies should be doing actually post-Brexit to comply with both slightly contradicting approaches?
Sure. I mean, I certainly think it's worthwhile considering both UK businesses and businesses that operate internationally, both in the UK and in the EU, need to think about how they're going to comply with both regimes. It's certainly not hard to imagine that both the EU AI Act and the UK regime will apply to the same business, because most businesses will be rolling out their AI tools or adopting AI tools in very similar ways, if not the same ways, across their organization, across regions like Europe. So, for example, where a business wants to deploy AI technology across the UK and the EU, or where a business wants to deploy AI tools in the UK only, but it might have effects in the EU or vice versa. In those situations, you need to be thinking about, well, how are we going to comply with both the more stringent EU AI Act requirements in terms of risk rating and controls, and also the guidance that is issued by different regulators in the UK. So
Very
definitely more food for thought and more topics to explore later on in our podcast series.
Exactly, and that's a very nice, leading to my next point. Everybody stay tuned. This is a series, as Oliver said. So some of the topics that we will really focus on in next episodes are who should worry about this, right? So we'll talk about the applicability concretely of the UAI Act and other European developments. We'll talk about the very specific obligations that arise in these different scenarios. If I'm a provider of a high-risk system, if I'm a provider of a general purpose AI model, or if I'm a deployer of both of those, or if I just have a limited risk model like a chatbot. So we'll take a deep dive into those concrete obligations. Another one, we'll talk about IP and AI, so IP implications from a global perspective. We'll have Oliver and I as co-hosts, we'll have guests on this podcast, and as well as obligations between developers and providers and deployers, and how that will play out, basically, tech transactions considerations, if you will. These are just a few, so stay tuned, and we hope that you will hear from us again very soon. Thank you very much.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.